and law advocacy competition in collaboration with the Bar Society. Kathy.
Thank you. Thanks very much. Thank you to everyone who put in a skeleton argument for this competition. The standard was very high and I found it very difficult to choose a winner, but I have done. So I've got first, second and third prize. And the prizes, I think, are for first and second place are book tokens, and the prize for first place is a mini pupillage at Tanfield. So in third place is Holly Pickerel. In second place is Lika Jetakova. And in first place is Cameron Nielsen. So well done. Very many congratulations on that.
Thank you so much. And Katie, just from myself, I'm Catherine, who you've been so kindly corresponding with about this competition for so long. And I'd just like to extend my thanks to both Tanfield and to you personally for all of your support with organising this competition and just how wonderful you and patient you've been with me. So thank you so much, especially so close to Christmas. We really, really appreciate it.
You're welcome. You're welcome, Catherine. But yeah, well done to everybody because the standard was very high.
Thank you for that. And congratulations to all the winners of what I hoped was an insightful and valuable competition. Can I please ask the panelists who've joined us today to briefly introduce themselves?
Yes, so I'm Katie Gray. I am a barrister at Tanfield Chambers. I'm 2013 call, so I've been practicing for 7 years or so. So I'm still a pretty junior at the moment, and I do entirely property work. That's what I do.
My name is Mark Glover. I was called to the bar in 1999, so I've been doing this for 21 years now. I'm also at Tanfield Chambers with Katie and Chris, and I've recently been appointed a Deputy Master of the Chancery Division, so I now sit as a judge in that capacity.
I'm Chris Heather. I was called to the bar in 1995 and I became a QC in 2017. My work is mostly property and property related professional negligence as well.
Thank you for that. Just before I pass the floor to Lika, who can start asking our panelists some questions, can I please talk about some housekeeping rules? Can everyone please mute their mics except the panelists so there's no feedback while we record this session? Lika, can you please start asking the questions now?
Yeah, so straight into our first question, which is, we would like to know, why did you decide to practice land law, and was it your aim from the very start, or did you find it fascinating while being on a mini pupillage, or a different kind of work experience?
Who wants to go first?
You can go first with that, Chris.
Okay.
Order that you started off with brief introductions, that would be great.
Oh, okay. You want to go in that order? So me first.
Yeah.
Okay. I don't think that it was. I don't think I had a particular kind of calling to land law or anything like that. I knew that I didn't want to do crime. I knew that I didn't really want to do family, and I wanted something that had a good balance of court work and written work. And actually, there's not very many areas of law where, as a junior practitioner, you can be going to court a couple of times a week, but also be doing a fair bit of written advisory work. And so that was what attracted me to property. It was that balance of court work and written work, and also the fact that even when you're quite junior in property, you're often doing your own cases right from the start, rather than being led as you might be if you were in somewhere more kind of commercial. You would be expected to be led for quite a few years by a more senior barrister, whereas in property, often a lot of the stuff that you do is your own stuff, and I found that quite attractive. So that's why I went for property. And also they gave me a pupillage. They're quite hard to find. So.
Well, for me, it's kind of hard to remember now. It's about 25 years ago that I was at university, but I do have a recollection of having a very funny land law lecturer at university. He was a former solicitor, and he really brought the subject to life with practical examples from his former practice in relation to conveyancing and land law. Made it a bit more enjoyable for studying, and I think I was also a bit of a secret geographer, and so that's maybe what drove me towards focusing on land law.
Well, for me, it was a complete accident. It wasn't my career plan at all. I thought I wanted to do public law and administrative law, and that's what I did my pupillage in. But when I've been at university, I was good at land law, and I found myself in pupillage doing property work, and it sort of stuck to me. So I didn't get taken on as a tenant in the place where I did my first pupillage, and I ended up moving somewhere else, but the property work stuck to me and I couldn't get rid of it. In fact, more and more stuck, and it just seemed to be that's really what I was destined to do. It's one of the funny things about the bar. You can't always choose what you end up doing. Sometimes it chooses you, and I was very much a victim of that.
Thank you for such a great insight. So land law is obviously a very broad term, and we would like to know what this practice area actually entails. If you could explain to us, and which aspects do you find the most fascinating?
Should I tell you what I've done this week, or what I'm doing this week? That's probably kind of the best way of working out
Yes.
what I've got going on and what my day-to-day practice involves. So, okay, so this morning I did a freezing order in a trusts of land case. So that was a case where some people had bought a house together, and only one person's name was on the title, and one was saying, well, actually, I own half of this. And what happened in the interim was that part of this house had been sold as a flat, and so we had to go quite urgently to court to get a freezing order to protect the proceeds of sale pending the claim. So that's what I was doing this morning, which was good fun. I've got a 2-day service charge trial later on this week, so that's just going to be kind of it's 2 days on effectively Zoom, because we're not having in-person or very many in-person court hearings at the moment. So I'll be sat here in my dining room trying to conduct a trial about a residential lease of a holiday park. So that's this week. And then what else have I got to do? I've got to do a defence for a claim in the land registry about a prescriptive easements, and you'll have learned about prescriptive easements on your land law course. And when I was learning about prescriptive easements on my land law course, I just didn't understand them. I'm not sure I definitely understand them now, but they are a lot more fun to deal with in practice when you know the facts than on paper, I found. So that's the kind of thing that I do, and I've done this week.
It is a broad term, land law. It covers all the subjects and topics that Katie's just spoken about. Ownership of land, so equity and trusts, land registration, boundary disputes. That's something I enjoy doing, boundary disputes. I think Katie quite likes boundary disputes as well. Rights and interests that people have in land, so leases and rights of way, easements. Rights and interests that people have over land, so dealing with mortgages, charges over land. For me, I've always enjoyed doing cases that have a historic element to them. So that's usually things like boundary disputes and rights of way, where people have been claiming interests of land for a long time. I quite like looking at maps and plans, and so that's where I often find the most enjoyment in land law. I'm like Katie, we have a very wide practice. I have a boundary dispute on tomorrow to deal with, and today I've been dealing with fraud in land registration. A case I think it's going to be worth something like £200 million worth of fraud to do with property. So yeah, I mean, it's a very wide area.
My work covers a range of things which are typical of land law in practice. So the Land Registration Act, which is probably something that you've already spotted in your studies at university, does feature pretty largely in a property practitioner's repertoire. It's really important, if I can tell you that now, to get to grips with it sooner rather than later. And that covers all kinds of things. You name it, you can find it somewhere in the Land Registration Act. So that's a big area. Another area which we do a lot of in Chambers is landlord and tenant, which in the olden days was actually not treated as part of land law at all. But this isn't the time for a lecture about the histories of the laws of England and Wales. But historically, it was dealt with differently and practiced by different people. Nowadays, you tend to do both, so landlord and tenant. And that itself covers a wide range of disputes. So service charges, like Katie's mentioned, but also disputes between commercial landlords and tenants. And obviously, there's a lot of that around at the moment with so many businesses being shut because of COVID. And then I may have mentioned it in my introduction, there's all the mistakes which get made by professionals, often solicitors, sometimes surveyors, and sometimes barristers in property disputes. And they give rise to claims for professional liability, which can be really interesting because you need then to understand two areas. You need to understand the basic underlying property principles, but you've also got to be on top of the negligence concepts as well. And a lot of property practitioners, particularly in specialist areas, so subdivisions of property practice, tend to have a negligence practice as well for dealing with professional liability. So I think that's an overview from the three of us as probably the big areas which fall within property practice.
Thank you for this. So obviously land law is a very complex subject and actually the one that a lot of students struggle with, especially in their first year at Queen Mary. So we would like to know about your experience with the subject during your time at the university.
I think I did it in my second year actually, which was easier because I kind of knew a little bit more about what law was. I think if I'd have come into it cold as a first year student, I really wouldn't have understood. But I think I did all right. I can't really remember what I did at university, but I think it went okay. I can't remember it being dreadful, but I also can't remember having any particular great passion for land law, the land law that I studied at university. For me, it's one of the subject areas that comes alive when you're actually practicing it and when you've actually got the people in front of you who are in the dispute. Although I do remember when I was revising for my land, I think either land law or equity that I was revising for, I used to Google Street View the houses involved so that I could kind of remember, I could link the houses to the facts, and that has been the kind of thing that shows you that it really is more in the facts and the practice that it's interesting than on the paper and in the book. So yeah, I probably did find it a little bit dull, I have to say, but it's not dull. I don't find it dull in real life.
I sort of have to echo what Katie said, which is I think that the difficulty that the average law student has, especially in their first year, is that they've not had any practical experience of land law. Most students haven't bought a house, they've never had a mortgage, they've probably never had a lease, they've never been a tenant. So it all seems very alien to new students, and they don't have any practical familiarity with land on which to build the subject. I think that's obviously part of the job of lecturers, is to help bring the topic to life. As I said, at university, I had an excellent land law lecturer who made it a bit of fun. But as Katie says, it's often now in practice is where you get to apply the law to real facts, that it comes to life. And I think, the advice I would give to any student is be brave and say when you don't understand something that's being explained to you by your lecturer. So if someone starts talking about lost modern grants, don't be afraid to say what's a grant if you don't know what a grant is, because if you haven't got the basic concepts, you're not going to understand everything else that follows.
Yeah, well, it seems like Mark and Katie had slightly better experiences in their teaching than I did. I just remember it being really badly taught by some very eminent people, but it was, at the time I studied it, a syllabus that was rooted in the 19th century, and it didn't have any practical application at all. I mean, I think that the most recent bit of legislation that was on my syllabus was the 1925 legislation, and I think that that has pretty much changed since then. As Katie said, it's all about facts, and the nice thing about land law is it's about people as well. It's one of the comparatively rare areas where you've got a physical thing, but you've got people as well, and that's one of the reasons why in practice it is generally so much fun. It's got complicated law which really pays from careful study, and it's also an area where the more you read, the more you know, and the more you know, the better you get. But it's got these extraordinary facts, and the cases which you'll be reading as part of your land law course, if you do the kind of thing which Katie suggested, which I think is absolutely brilliant, and actually look at the property in question, it just brings home to you what an extraordinary situation almost every land law case has arisen out of. So if any way that you can find to bring colour and interest to the areas will really repay, and that's why in practice land law is so much fun, because you're actually dealing with what in some cases are extraordinary and often unbelievable factual situations which you frankly couldn't make up, and sometimes people don't make up, but you never know. So.
Thank you. So as you have mentioned a lot of cases, we would like to know whether you remember your first case you worked on, and if you do remember, what did you learn from that experience?
Yes, it was horrendous. So I think it was a 2-day trial, a trust of land trial, as far as I remember. But I don't think anyone had like trusted me with a 2-day trial. I think my client was only playing a small part in it. I think I was just there to take a noting brief. And for some reason, I can't remember, it just went mad. And my client's role became way more important than anyone had thought it was going to be. And I had to agree some stuff, some orders, had to argue for costs. I just remember it being completely terrifying. I think we got there in the end. I think I was sort of on day one, I ran back to Chambers into my pupil supervisor's room and was just like, help, I don't understand. So that was good. But yeah, it was terrifying. I was kind of hoping for a sort of straightforward possession hearing, but that wasn't to be.
Now, I've been fortunate to share a room with Katie for a number of years, and I thought Katie's first case was a 5-day contempt of court hearing where her client had burned down a warehouse, but that might have been the second awful case. My first experience in court by myself was in Highbury and Islington Magistrates Court, a very glamorous building to take your first brief in. And my client was charged. He was in the dock for having been involved in shoplifting. So I suppose it had that property element to it. What did I learn from that experience? Well, he presented in the dock with a saucepan on his head, with a scarf wrapped around it to hold it in place. And he explained that this was to stop people being able to read his mind. So I guess I learned from that experience to be adaptable and take things in your stride with your lay clients.
Well, my first appearance in court on my own was a lot less exciting than both Katie's and Mark's. It was an application on behalf of a tenant to suspend a warrant of execution against their home. I was acting for the landlord, resisting that application. I'm pretty sure that the outcome was that the warrant was suspended on current rent plus £2.55 a week. And yeah, that was it. That's all I can remember was that it was at Lambeth County Court in front of District Judge Zimmels. Yeah, it was probably very important to the tenant who succeeded in the application and effectively saved her home at the very last moment from repossession. And I guess that's why it's stuck in my mind.
Thank you for sharing, Dave. So when it comes to property and real estate, what do you think are some of the struggles that barristers face? And what would be your advice to students on how to deal with these struggles?
So I think the struggles that I face in my practice aren't really to do with the area of law that I practice, because by now, you know, I've done a fair few cases. I know where to look for stuff. I know who to ask for help if I don't know the answer. So, and also, I only get given work that's appropriate for someone of my call. So, so in terms of like the actual day-to-day doing the job, I don't really have very many struggles. But for me, it's more of a kind of work-life balance struggle. So it's boundaries, but not in the land sense. It's boundaries in the sense of I need to have more boundaries between my work and my life. So yeah, I find that especially now that we're all working from home in this kind of COVID era, it's quite difficult when your office is in your dining room to kind of switch off switch off your computer, focus on something else, and have a bit of a life, especially when you've got emails coming in to your phone and stuff at all hours of the day. So that is something that I really do struggle with practically day to day. But it's not really related to property. It's just, I think, related to work generally.
I mean, first of all, I think I again echo what Katie says about we're all now slightly living at work, and that is something we all have to try and manage. But I think going back to property and land law, one of the struggles that I found a little surprising when I first started out was that land cases, property cases, are often very emotionally charged, the equal of any divorce case. And that might just be a particular trait of this country. We're very protective over our property rights. So you've often got quite emotionally charged clients, and invariably these days you're also dealing with high value interests in properties worth a lot of money in this country. So you've got client management in high value litigation to deal with, which has its own particular stresses. Also, demands on work turnover are very high. When I first came to the bar, everything was done by fax and telephone. We didn't have email. Chambers didn't have email addresses. You might be expected to turn work around in 2 or 3 months. Now people require work in days, if not hours, and you're on email constantly, and you're constantly being chased by email. So there's a lot of pressure that comes through that, and you just have to get better at time management.
My view of the particular struggles which associate with property and real estate is the fear of getting it wrong. It's a technically very difficult area, and as I said earlier, it's an area which really does, in which you profit from the more you read and the more you learn and the more experience you get. But there is always a nagging doubt that you've missed something, either a recent case, but more likely a whole point related to a statute or a principle which you haven't initially thought of. So often a client will come to you with a problem which presents as situation A, but the more you think about it, you realize that actually there's a completely different analysis that could be put upon it from the one that was originally suggested to you. And it's the opportunity to find that which might be the point that wins the case for your client, against the fear of missing it. So I find that it is possibly one of the most easy areas in which you can miss something important. And so you just have to learn to think about everything that comes in as many ways as you can. Ask yourself, what am I missing here? And it's also an area which you ask your colleagues quite a lot about as well, for exactly that reason. It's a very much a tradition at the bar that you can run something you are doing past colleagues on an anonymous basis, get a second or third opinion. That's what we do in Chambers, and it's always an informal kind of chat. In the olden days, it was over a cup of tea. These days, it's over the internet or by phone. But yeah, it's that's the way that you tend to avoid missing those traps. If you're on your own, land law, I think, really would be a struggle.
Thank you. So what do you think are the key personal traits of a successful land law lawyer, and how would you advise our guests to develop those skills?
Well, research skills, so building on what Chris has said, using your research skills to find the right answer, knowing where to look, knowing where to find your information, and then finding the relevant part of a case or book is helpful. Being able to ask for help is something that people do struggle with. I really struggle with asking for help because I worry that people will think I'm stupid if I ask for help. So so knowing that you're able to do it and doing it is a skill that I think actually is quite difficult to acquire if you're a certain kind of personality type. Organisation, obviously, and kind of the ability to think clear-headedly when you're kind of facing unexpected stuff from judges and clients all at the last minute. That's trying to sort of be calm and think your way through a problem kind of quickly but calmly is a skill, and you can develop that in all sorts of ways by mooting, for example, debating. Those sorts of activities will help you think on your feet much better.
Well, I think Katie's covered pretty much all of it. You've got to have a fondness for reading. You've got to be keen on reading lots. As Chris has said, you've got to read into the subject, and the more you learn about the subject, the safer you will be and the happier and more confident you will be practicing in land law. You do have to have academic ability. It is a technical area of law. I think it's also important and useful to have a wide knowledge of all areas of law, or a lot of areas of the law. So land law will often overlap with family disputes. So sometimes you'll be talking to your colleagues who are family practitioners about issues particularly in relation to ancillary relief and divorce. Business and company disputes, usually what they're really fighting over is the underlying property, the lease to the restaurant or the gymnasium. That's what they're really fighting about. Banking law, mortgages, immigration. It's good to know a bit about immigration if you're doing landlord and tenant work these days, because there's certain obligations on your clients if they're landlords in relation to letting properties. Tax, it's good to understand about tax. You can, VAT comes up in transfer of properties, especially businesses. Company law, planning, obviously we're often dealing with issues where we overlap with planning law and construction law, to name just a few areas of the law that are complementary to land law and where it's good to be comfortable. I think you've got to be keen to continually learn. You never stop learning as a land lawyer, and you become expert in all kinds of weird and wonderful things you never thought you would become expert in, such as how a gutter is attached to a building, when you're dealing with an overhanging trespass case, or the different types of fence posts that were available in the 1920s or in the 1950s. How large is a turning circle on a heavy goods vehicle? How quickly can a herd of sheep, flock of sheep run, and can you outrun them? So I think another key personal trait, if you're going to do agricultural land law, is to make sure you're relatively fit. So yeah, there's a lot of things that came as a surprise to me when I began practicing land law, but it is very satisfying because you get to find out about all kinds of interesting things that you would not have had reason to learn about. How do farmers dig a ditch and put a hedge on top of the ditch? How does that work in practice?
Yeah, I think I agree with everything that Katie and Mark have said. I think, firstly, you've got to be interested in reading about stuff and following up footnotes and then reading about more stuff. I think with land law in particular, you need to have a brain that will follow a chain of inquiry, which can lead you down a rabbit hole and bring you somewhere else. So I think that's important. And I think in particular, it's you've got to like reading it from books. It's not an area which you can do particularly easily simply by typing in search words in Westlaw or Lawtel. So you've got to like that. I think the second attribute is no stone unturned. You've got to be someone who is really prepared to think about it from lots of different points of view. And I think thirdly, picking up on Mark's point, it really helps if you're interested in stuff. Yeah, if you're prepared to devote your life for a period of time into finding out how gutters work, or about sheep, or about how stone steps used to be carved in the 19th century into cliffs in coastal villages. Doesn't matter what the case is about, but there will be inevitably some area of knowledge which you will develop in that and become, for a limited period of time, a complete expert in. And one of the nice things about doing property law is when you walk, cycle, bus, drive, however it is, around London, around the country, you see buildings that you've been involved in litigation over, and the lucky occupants of your car or your lucky fellow passengers will be regaled with amazing stories about how the lift works in that building, or how much each of the tenants paid to have the new windows fitted to the tower block. So you will become a wealth of all kinds of wonderful information which will benefit absolutely everyone you know. So the many joys of land law.
Thank you for your helpful tips. So when it comes to being a self-employed property barrister, what are the pre and post COVID-19 struggles?
I think post COVID-19, one real struggle is meeting clients and talking to them and kind of marketing yourself to them, because we used to go out and get, we used to go out to parties and have fun and invite people out, and we can't do that anymore because it's illegal. So it's quite tough kind of connecting with people and meeting new people if you're stuck at home. So that's hard. Remote court hearings are just like awful. I find, I don't know, other people might have different views, but I find particularly telephone hearings are just incredibly difficult to read the court and to read what someone is thinking and what someone's doing on the other side. So so those are two particular struggles that I have found post-COVID.
Yeah, I mean, I think the struggles of being self-employed as a barrister are probably universal, and they include making time to market your business and find new sources of work whilst you're maintaining existing relationships and doing the work day to day. Ultimately, it is down to you as a barrister to develop your own practice and maintain a pipeline of new work. That hasn't got any easier during COVID. As Katie said, we're not allowed to go out and meet people and socialize and get linked in that way at the moment. So that is a difficulty. I mean, one of the things that hasn't really changed during COVID is that barristers have always worked from home and enjoyed flexible working practices. So it's nice to see everybody else starting to get some of the pleasure of not having to get a train every morning and go into an office. To some extent, COVID has made practice a little easier. It's accelerated the shift towards remote hearings by telephone and Skype and Teams, and I'm sure there are other good platforms available. That's enabled you as a barrister to take on a case in Manchester in the morning and then a case in Exeter in the afternoon. Something you couldn't have done easily before COVID and before we really had the shift to remote court hearings, because obviously there just wasn't time. If you had a case in Manchester, even if it's only a 15-minute hearing, you'd be gone all day. You'd be getting the early train from Euston at 6 o'clock in the morning. You'd turn up for your hearing at 10:30 or 11. By the time you'd got on and got out, it'd be 1 o'clock. You'd be back on a train at 2, and you'd be back home at maybe 5, 6 o'clock in the evening. Whereas now, you walk into your study, you hopefully have remembered to put a suit and tie on, you do the hearing, and you're finished, and you're walking your dog or doing what else you do with your time afterwards. And so that's been a nice side of the change that's followed COVID-19.
I think pre-COVID, the big problem was getting away from chambers. There's always a temptation to stay a bit later, and sometimes you could end up working into the night just because you were getting carried away. So maintaining separation between your life and your work was difficult pre-COVID. As Mark said, in the olden days, we used to work from home, and that is one of the luxuries of the bar. So you could take it home, but nonetheless, a lot of the work that we do is based in chambers, and people who do property work tend to be in chambers which are physically quite busy and quite full of people, compared with some other areas of law. Post-COVID, as Katie said much earlier, the difficulty is getting away from it in a different way, because you're at home, and if you're lucky, you've got a separate room which you can work from, but not everyone even has that. There are a lot of young professionals and young barristers in particular whose working arrangements are such that it does make it difficult to work from home. So yeah, finding the balance between what is a very engaging and demanding job and trying to lead a life as well is, I think, the struggle both pre and post-COVID for any barrister, really.
So again, in the light of the current situation and the fact that we do most of our things online now rather than face-to-face, what is your opinion on progressiveness and effectiveness of e-conveyancing?
Can I be honest with you? Which is that I remember learning about e-conveyancing when I was at university, and I have not looked at it again since university. It's something that has never yet come up in my practice. So I don't know is the answer. I don't know the answer to that question. You're probably better off asking some of the other members of the panel.
I'm going to butt in here and say that I agree with Katie and have absolutely nothing to add. Obviously, e-conveyancing came in after I was at university. I'm aware that there are provisions in the Land Registration Act and the land registry rules for it, but that is something which solicitors have to wrestle with. And I have never been aware of any litigation which has actually involved e-conveyancing, so I'm afraid I can't help. Mark, you've got to save us.
I mean, look, a number of commentators argue that the land registration system in England and Wales has created the market for overseas investment into our property, which has driven property values certainly in some areas such as London upwards. And investors obviously like the security of title that's provided by our land registration system. Now, e-conveyancing has, I think, simply made that system fit for purpose in the modern world. It's enabled transactional work to be undertaken more efficiently in time and costs. So it's driven down the cost of conveyancing, buying and selling properties. And it certainly has increased the confidence with which people deal with titles. I had a case on last month where we were applying for an injunction in the High Court, and the case, to all intents and purposes, to a large part, is going to turn on the fact that we managed to get our e-conveyancing in about 3 minutes before the other party managed to get their e-conveyancing done. So the move to e-conveyancing, it mirrors the way that we're now having to e-file everything at court as well. In the post-COVID world, we're obviously moving away from paper and contact, and really e-conveyancing is the only solution, and it's certainly here to stay. I think e-conveyancing, it's like e-filing at court. It opens up all sorts of opportunities for flexible working arrangements in terms of where lawyers are going to work from and the hours of the day that they're going to choose to work. So that in turn, of course, makes the legal profession more accessible as a career for people. So yeah, I mean, I don't know how much that helps. So I have had some experience in practice. I see it all the time sitting, and it's inefficient. It's an efficient system that is there, and it's effective for the new world order that we now live in.
Thank you. So our last question is that we all know that land law lawyers can be responsible for commercial properties, which involve working with international clients and sometimes including governments. So would any of the panelists wish to share their experience with such cases?
I've never been instructed by government. I await the brief. I'm sure it's coming. I do have some international clients. Like oftentimes, property owning companies are based offshore, and you know, I might need to deal with them if they're trying to seek possession of property or something like that. It really kind of comes up when the practical stuff, when you're looking at the practical stuff. So, you know, have they given proper notice to their tenants of their address? If they're abroad, you know, do they need to give notice of an address in England and Wales, and have they done it? And kind of more of those practical things that I tend to find myself dealing with and looking at with international clients rather than anything particularly juicy. That might be as a result of me being relatively junior, so I don't get that kind of cool work.
Okay, well, first of all, Katie's wrong. She has been involved in a case that involved an international client and a government at that. It was a case for one of the sovereign wealth funds of a very, very large country indeed, that was building a building in Sheffield. If Katie wants to tell us about that, she can do that. Now, that was an interesting case at many levels. We had to deal with the lay clients after that case, and they were quite powerful individuals we ended up having a supper with, but I'll leave that one to Katie. So, I mean, I've been fortunate to work for a number of governments usually through sovereign wealth funds and their property interests, again, in particular in London, whether it's the Shard or the Gherkin or buildings like that. I suppose the advice I could give is don't work for a state where you like to go on holiday unless you know you're going to win the case. And also the thing that surprised me as I started to work for governments is how many proxy wars seem to be fought out over property between state actors, again, particularly in London. So there's often a political element to disputes where maybe the landlord is from country X and the tenant is from country Y. And so you can find yourself in a case which seems to be a straightforward case, and then suddenly the parties are taking the smallest point in that case to the highest court in the land with no expense of being spared. And it's often only much later that your solicitor will divulge to you that the reason the parties were so entrenched was because behind party A was country X and behind party B was country Z, and they don't really get on very well. And that's what I mean by the sort of fighting these proxy wars through London real estate. So that's my experience of, for what it's worth, working for governments and international clients.
Yeah, there's not much I can add to that, really. There are a number of sovereign wealth funds with substantial interests in London, and we do come across them either acting for them or against them. There are invariably large commercial pressures, usually a degree of animosity as well. But that's something that can also feature in a very small scale dispute in a county court about where a boundary is. So the experience you get in property law when you're starting out does help you for when you go on to the bigger stuff, because the issues are generally the same. So it might be that you're dealing with litigation involving commercial offices or something like that, or very high value residential property in London. The same concepts will feature in that as in any other land law case. And likewise, if you're acting directly for a government, for example, the UK government, they also have property interests, own all kinds of commercial and residential property around the UK. And yeah, if you act for them, their concerns will be similar to any other client that you have, possibly with added complications associated with political angles or publicity, which you don't always get in a private dispute. But yeah, the great thing about practicing law in this country is no matter how big or how small you are, the same principles do apply, and the courts do apply them, and there isn't any sort of favoritism on that perspective.
Thank you. I think we can now turn to the chat box and Hamza will ask the question.
Thank you, Lika, and thank you to everyone for answering all those questions. I found them to be really insightful. The first question we've had is, as the pupillage season is nearing, do you have any advice for budding pupil barristers?
I'm on the pupillage committee, so I can probably help with that. The one thing that we find with applications that makes us turn them down is where it's quite clear that someone's just made a scattergun application to every chambers going, and they said exactly the same thing in their application form. And there's a specific box on our application form that says, why do you want to come to Tanfield? And that box really needs to be filled out with a bit of care and a bit of thought. And if you've kind of seen any work that people at Tanfield have been involved in, then it's a good idea to mention it and to say why you found it interesting. If you've met anyone, for example, at an event like this, don't worry about name dropping. I think that's quite a good thing to do. But yeah, make sure that you make it specific to the chambers that you're applying to, and specific to the area of law that they do. So show a real interest in what they're doing. That's the one thing that we find gets us to kind of turn application forms away more than anything else.
It's been a long time since I was involved in, or was myself applying for pupillage. And I don't want to cut across anything Katie has said. I think when I applied for pupillage, I certainly applied to a lot of sets, but I think it was done slightly differently back then. But what I did do was I did tailor each of the applications to the set. And in fact, I handwrote each of my letters, my covering letters with my CV. I handwrote them each out. It took about a month to do. And I did that because somebody had said to me that when they received handwritten covering letters, it showed them that you'd really thought about applying to them. So that's a trick I used. And I think what you have to also remember when you're applying for pupillage is that, like everything in life, there is a large amount of luck involved. So the pupillage that I managed to secure for myself I can remember traveling into London on a Saturday morning. I don't know if that's when we still do pupillage interviews, but it was when I was applying. You'd do it on a Saturday or Sunday. And I can remember getting the train into Marylebone, and I went down to Oxford Circus to change onto the Central Line, and it was quiet. It was a quiet Saturday morning, and I held the door on the tube train carriage for someone to get on the train with me, and made a bit of small talk, not much. I got off at Holborn. This is a very particular story, isn't it? I got off at Holborn, came up, walked down to Gray's Inn, which was where I was going for my pupillage interview. So I had a good sense that I was going to the right place. And I walked into the interview room, and the person for whom I had held the carriage door was the person who was interviewing me. She was the deputy head of chambers, and she said, "Oh, I need to hear from you. You've got a pupillage here." So, and that was a bit of luck. So you do need a bit of luck, but at the same time, of course, I'd had to put in an application, and I thought through the process of making that application to that chambers to get my foot in the door there. So yeah, I mean, that's what I think I can share.
My advice would be to find out what the chambers who are interviewing you have been involved with over the last months, possibly year. Find out if they've been involved in something which has been topical or which has made some new law, and ask them some questions about it. Show that you've done some research. Show that you understand the areas of law which those cases involve, because then you're likely to be on the same wavelength as some of the people who are interviewing you, if not all of them. I think it's just part of getting properly prepared for an interview. Have some thoughts about developing law that's associated with property, land law, landlord and tenant. Is there anything being debated in Parliament at the moment? Is there any white paper? Are the Law Commission in the process of looking at anything? Have they recently reported? So be aware of that kind of stuff. Show that you're interested in law of the kind that the set that you're at is practicing.
Thank you for those answers. I'm going to move on to the second question we have, which is, what non-law related work experience do you think is particularly useful for those looking to practice land law?
Oh, land law specifically, I don't know that there's any particular non-law related work experience that would kind of go towards a practice in land law specifically, unless maybe you've been a surveyor in a past life, or I don't know, worked for a property owning company. Perhaps that might be something. You know, if you worked for a company that owned a lot of residential properties and you had to help with the administration of those. I mean, non-law work experience, really, I think we're just looking for anything that shows that you've got some experience of the real world, you're committed to working hard. I mean, my non-law work experience when I came to the bar was like stacking shelves in Tesco at night. That's what I did. So I don't think it needs to be anything stellar. I think the point is really to show that you're a committed person who's had some experience of the real world, or albeit you're kind of fresh out of university.
I mean, Katie is again, and I think Chris sits on the pupillage committee, or has done more recently than I have. But the sort of experiences that I think are probably valuable are things like mooting and getting involved in, free representation unit, and anything to do with the law and practice. But other than the law, as Katie says, if you've worked, had some work experience with surveyors, that wouldn't hurt. I had a job when I was about 18 or 19, cycling around footpaths, checking the condition of footpaths. So I had my plan, my big plan, and I was going around and finding these rights of way and helping to help the local authority to decide whether the rights of way were in public use still, and if they weren't, when did they fall out of public use. So that was a job that was quite useful. I didn't realize it would be useful, but it was quite useful for later on wanting to do land law. And I think the other job I had was working for a local authority doing filing. But as Katie said, I don't think it really matters. I think we just want to see that you've had some life experiences and that you've had to deal with people, whether it's dealing with the public, because that's an important skill to have. How do you deal with people? Because a lot of what you do as a landlord is going to be dealing with your clients and sitting down and listening to them and being interested in what they want to tell you about where their drains are running and what the problem is that they have with their fence or why they don't like their tenant. So you've got to be able to deal with people. And you can get that sort of skill from working in a shop and being client facing in that way. And I think that's the sort of thing we want to see that you have. And on top of that, if you've done mooting, if you've been involved with your law society, if you've been involved with any charitable institution that provides legal advice or guidance to members of the public, that's all great stuff as well.
Yeah, I agree with Katie. I mean, we're all I think in the same position here in that we've had a range of different jobs before becoming barristers. I mean, the two which I did, which are memorable for different reasons, are I used to push a tea trolley around an office that was owned by British Telecom, and I used to make tea and coffee and hand out sandwiches to people who worked in that office. So I learned how to make coffee for different people and how to remember people's orders. And I also worked in the canteen for Bernard Matthews Turkeys, which was basically a job of cooking breakfast for a shift of 400 workers who would come in at 6 a.m. covered in feathers, basically. And yeah, so as Mark says, it really helps if you can relate to people and their problems in this job. And it doesn't matter what the jobs that you've done are, as long as you've done something which will give you a bit of that experience and might be the kind of thing which shows that you are someone who can bring something to the law, because I think that's really what it's all about.
Thank you for that. This is the last question we have for now. The question is, speaking of flexibility, would a pupillage or even the earliest stage of a tenancy be compatible with pursuing parallel commitments, such as studying for a master or a PhD, rather than practicing as a teaching assistant on a part-time basis? I hope you guys got that.
I think it might depend where you have your pupillage, because I don't think it would have worked where I was at Tanfield for my pupillage, and I was, and also obviously for the early parts of my tenancy, and I was busy the whole time, and I don't think I could have done it part-time. It may be that they might have come to some sort of arrangement with me had I asked, but I would have been concerned, I think, especially if I was in competition with another pupil who was full-time. I think I would be concerned about that affecting potentially my prospects for tenancy. And then if I was part-time as an early tenant, I would have felt that would have affected my ability to kind of properly get myself established as a junior practitioner if I wasn't around half the time. So I don't think it would have worked for me. That's not to say that it wouldn't work for other people, but I don't think it wouldn't have been my thing. Also, I'm not clever enough to do a PhD.
I mean, from my perspective, Katie is clever enough to do a PhD, but I think also I couldn't imagine trying to do another job whilst becoming a barrister. It's very intense. It's great fun. It's lots of fun, but you're having to get to know everyone in chambers and get to know the personalities, having to learn how to do this new job. All of the stuff you just can't learn at university, you're having to pick up, because quite a lot of what you learn at university isn't going to help you in front of that unpleasant judge on a Monday morning. So you've got to learn this whole new skill set. and there's just so many demands on your time. I haven't yet got to a point in my practice where I'm not working weekends, and so the idea of trying to squeeze in study time as well, I don't know where I'd find that time. But I guess if you're happy for there to be some impact on how busy you are at the bar, then maybe it's easier to do. But we are, as we said at the start, we're self-employed, and we get generally we get paid by the hour. So there's only so many hours in the day you can work, and therefore there's only so much money you can earn as a barrister. And if you're happy to give up some of those hours to do other things, then maybe that is possible. But it's always very hard to know what you can say no to, what piece of work you can say no to, because you're never sure where the next piece of work is coming from. And so that's one of the problems in having this myth of a wonderful work-life balance at the bar. You're just not sure that if you say no to a brief because you want to be studying for something else, that you're going to get another piece of work 2 days later. That solicitor is going to come back to you and want to use you later on that month. What you need to be doing is building up your relationships and finding that work if you want to have a successful career at the bar.
Yeah, my contribution to this is, because you're self-employed, there is flexibility. It is compatible with all manner of things, including parenting as well. But you just have to make it work. There is always a way of making it work because of the flexibility, but you've got to be careful. You need to plan your career and keep an eye on it, and make sure that however you are juggling your other interests and commitments doesn't affect the quality of what you're doing. It's perfectly possible to combine the bar with more than one other activity, and lots of people do. Some people very successfully. You just need to be very organized, and I think organization is something which pretty much all successful barristers have. You've got to be a master of time and be able to keep on top of deadlines, manage multiple things at the same time. And so ultimately it makes no difference if you're doing that as a full-time job or as other in conjunction with something else. So
Thank you for that. We have another question. This is the last question we have for now. Has personal property law ever featured or assisted you in the resolution of property and real estate disputes?
I don't know what that means. Sorry, I don't know what that means. Has personal property law ever featured or assisted in the resolution of property and real estate disputes? Sorry, I don't understand the question. It might be that someone else does.
Or maybe what the question is asking is, have we ever in our personal life property dispute that has helped us in our professional life?
I don't think it's helped me. I once built a party wall on the line of junction and completely forgot about the party wall act, but it was fine. My neighbour didn't care. But I don't know that that's sort of helped. My personal experience has helped me in my practice. If anything, it's made me realise how much I need to learn about the party wall act.
I think it goes back to what Chris said earlier. He sort of said that it's about bringing colour to your practice, and so things that happen in your personal life with property that you own, I think, can help you in your professional life. So if you're a landlord, it's going to help you understand a little bit more what it's like for your clients who are landlords and who are maybe really frustrated because they're not getting their rent. You can maybe have a bit more empathy for them. Or if you've been a tenant and you've had a problem with a disrepair in your flat, you might have a little bit more empathy for the client who's suffering disrepair in their damp flat, or their flat that's in some other way in disrepair. If you've had a dispute with a neighbour over your boundary, then you're going to be a bit more aware of the emotions that can be at play when you are dealing with that in your professional life. So I think there's probably there is a bit of blending that goes on from your personal experience into your professional life. I think that's probably true for all professionals.
My take on that question is that it's something to do with the law of personal property, the law of chattels, as opposed to law of real property. And yes, it does occasionally come in. You have in landlord and tenant law in particular, the concept of fixtures and fittings, and concepts of personal property law therefore kick in there. This is possibly something that you've learned on your landlord course already, but it goes back to something I said earlier. Originally, the lease as a legal concept was an item of personal property. It was what's called a chattel real, rather than an item of real property. So those who work with landlord and tenant actually deal with a form of personal property every day. But that's probably too much detail for this evening.
Thank you for that. Seeing that we have no more questions, I am going to conclude this event. I would again like to take out a moment to thank all of our honorable panelists for joining us today and giving us their valuable time, particularly considering that it's a busy Monday. Secondly, I'd like to thank everyone who attended the event, and I hope they found it insightful. I hope everyone has a good Christmas break. And again, thank you to Lika from the Queen Mary Bar Society for doing an amazing job hosting this. Thank you, everyone. Take care and bye.
Thanks. Bye.
Thank you.
Bye.
Thank
Bye.
you. Bye-bye. Have a good evening.